Good evening. Welcome to our second evening webinar on the topic of child maintenance, child custody, and divorce, dealing with various issues regarding family law. If you joined us last night, we dealt with quite a few questions, about 9 pre-created questions, and there was somebody that posed. Welcome to our. Sorry about that. And someone posed a live question as well. If you are watching this webinar via Facebook Live, please make use of the Advocate Mohammed Abduroaf Facebook page if you wish to engage and pose a question. Otherwise, please enjoy yourself, listen to the various questions that are on the screen, and hopefully we can deal and assist you with this. I'm just giving some people a few moments to join us. And I think we're ready to start. Thank you again, and apologies for that, some technical issues we had now at the start. Nonetheless, question number one. Question number one. What do I do if I no longer can afford the maintenance order? Interesting question, a very valid question, in the sense of the same way in which someone applies for child maintenance and he or she obtains a court order. The court will obviously make the decision regarding the amount based upon the circumstances before it, the income of the parties, and the needs of the minor child, and of course expenditure of the parties as well. However, should there be a change in circumstances, let us say the person who should be paying the child maintenance no longer can afford the child maintenance, and under those circumstances we have to relook the matter again. We need to go back to the drawing board and determine what is a fair amount of maintenance to pay. Therefore, if someone no longer can afford to pay the child maintenance, legitimately, of course, let's say, for example, the person lost their job, or what sometimes happens is the person acquires additional expenditure, he or she may have another child, or he or she may have, lost business, or had to buy something very important for their survival, and of course, it affects the amount of child maintenance that gets paid. Obviously, the court will have to be reasonable, and the court would have to look at all the circumstances. What is the reason why the maintenance no longer can be paid, and so on. But if the reason is legitimate and is justifiable, obviously the court will have to relook the matter and recalculate the amount of maintenance to be paid. But then what do you do? So if you no longer can afford to pay the child maintenance, you need to approach the maintenance court in order for the maintenance order to be substituted with a new maintenance order, a maintenance order dealing with a new amount, a fair amount. And in order for you to do that, you approach a maintenance court, you fill in a form, a specific form, I think it's Form B, at the maintenance court, outlining the change in circumstances, the reason for making the application. You will, of course, outline your income, your expenditure. If you have no income, obviously that will be zero, etc. And ultimately, the court will call in the other party, the caregiver, the person who has the maintenance order in his or her position, or in whose favor the maintenance order is in. Usually the mother, and sometimes the father. It happens quite often when it's the father. And the court will have to relook the matter, and once the court determines, yes, there is a case for a reduction or substitution or setting aside of the maintenance order, the court will make such an order after listening to all the facts before it. The information submitted by the applicant, could be the father or the mother, and by the respondent or the complainant. Nonetheless, the court will have to be fair and make a decision that's fair to all parties. So let's move on to question number 2. I live in Cape Town and the mother of the child lives in KZN. Which maintenance court should I approach to reduce the amount? So here we have a scenario where the father has a maintenance order, let's say, against him. He has to pay maintenance to the mother. He lives in Cape Town, the mother lives in KwaZulu-Natal, and he would like to reduced amount. Can he approach the maintenance court where he lives, or should he approach the maintenance court where the child and the mother is? And of course, the answer would be that he needs to approach a maintenance court where the child and mother is, because that's a maintenance court that deals with this matter. Therefore, long story short, we all know the answer now. Please approach a maintenance court in your area for a reduction in child maintenance. Then question number 3. Oops. Sorry about that. The father of my child lives in the UK. How do I apply for child maintenance? Interesting question, something which many people do not know how to deal with. Obviously, the way the Maintenance Act is written and implemented is based upon the assumption that both parents lives in South Africa, and by that being the case, it's quite easy for the courts to reach out its arm and sort out the issues. The court can issue subpoenas, make orders, and so on, and it has the authority to do so because the parties are living in South Africa. However, should the minor child and the parent live in a different country, of course, a South African court or the maintenance court in South Africa does not have the authority or the power to tell another court overseas what to do, or tell another authority or another government what to do and how to do it. We only have authority to deal with our own country, and in terms of what the law stipulates regarding our country. For example, the magistrate's court would have power within its jurisdiction to deal with certain type of matters. Of course, if it makes an order, the order is obviously applicable to other country. Regarding international maintenance, we have agreements with various countries whereby you apply for maintenance initially at your magistrate's court, at your maintenance court where you reside. The court will look into the matter, the court will deal with the issues, the court will make an amount, a provisional amount. Of course, the court does not have any details from the other party because the other party is overseas. But nonetheless, an inquiry will take place locally, and that specific information and that interim order would be sent via diplomatic channels. In South Africa, is the Office of the Family Advocate, to the other countries' authority dealing with the child maintenance issue, where the father or the mother resides in the other country, in the foreign country, and they on that side will do the necessary checks, the necessary inquiries, and so on. And once they have concluded that, based upon the inquiry that took place in South Africa, that it is fair and it's reasonable and the information provided is adequate, and they've obviously received now information regarding the other party in the foreign country, they would make a maintenance order, and that order would obviously be made against that party living in that country and sent again via diplomatic channels back to South Africa for us to legislate here as well. So, long story short, it's possible to claim maintenance internationally from the other party. However, in order for you to do so, you must ensure that there is an agreement between South Africa and that specific country regarding international maintenance enforcement. So here we apply to the Reciprocal Enforcement of Maintenance Orders Act, the REMO Act. You can Google it and you should find some relevant information regarding that. I see we have some technical issues regarding connectivity. I do not know if it's on my side or somewhere else, but nonetheless, I shall proceed. Child custody. A very interesting topic. Nonetheless, the issue is, in this specific question, what is shared care? Now, in order for you to understand what shared care is, maybe we can firstly explain what would be the general contact and care arrangements that applies. And generally, one party would have primary care, where the child will live with that party or that parent during the week. That parent would attend to schoolwork, homework, making sure that everything is in order. And then every second weekend, the other parent will come and have contact with the minor child. And then once that weekend is over, the child will go back to the other parent and attend to day-to-day activities. During school holidays, the parties will generally share care, contact, or custody, where the minor child would live with one parent for one half of the holidays and with the other parent the other half of the holidays, which is fair and easy and simple, and it should work going forward. However, the premise is that one parent would deal with the minor child's general needs, education, psychological emotions. So if the child is generally ill or whatever, um, that specific parent would have the skills and the capacity to deal with the minor child. So the minor children, that is my home. I'm generally by my mom or my dad. He or she will care for me properly, deal with my homework, deal with my extracurricular activities. If there's problems with schools, that specific parent will contact the school and deal with the schools. The other parent would basically have contact on a weekend just to have some type of communication and to bond with the minor child to a certain extent. But the child would have his or her primary home to reside in. Sometimes they add in midweek contact as well. So that's a general scenario with a reasonable contact where one parent has primary care and the other party has a reasonable contact. Every second week and half school holidays and so on. Then you're dealing with issue concerning shared care where the minor child spends half the time with one parent and half the time with the other parent. So in a 30-day cycle of a month, the child will spend 15 days with one parent and 15 days with the other parent. How that works could either be, for example, 1 week with one parent from the Friday 5 o'clock until the next Friday at 4:59 or 5 o'clock, where they will do the swap, or one parent will drop the child at the other parent who should be exercising contact, or the parent who has not exercised contact for the last week would collect the minor child from the parent who has contact, who has care. So that's the general way it works, either 1 week, 1 week, or 3 days, 4 days, depending upon the circumstances. In that way, they might be able to share the weekends where the child would live with one parent every second weekend. So that's shared care, the shared care arrangements. It works very well if the minor child lives close to the various parties and the school is generally equidistant, very easily accessible by both parents, and at the same time it works really well if the parties can come to an agreement regarding that. But every case is different, all circumstances are different, and we obviously want to apply the principle of what is best for the child. The child might want it, child might not want it as well. One parent might want it and another parent might not want it, but it depends upon what's best for the minor child. So that's shared care, equal sharing of the minor child's time. Question number 2. What are guardianship rights? So guardianship rights would be easy for me to explain if I compare it to custody rights. So custody applies to the actual physical caring of the minor child. The child stays with you. So you're looking after the child. So you basically have custody, or you're exercising custody. With regard to guardianship rights, that applies to legal aspects. For example, should a child apply for a passport, if you have guardianship rights, your consent is required. Should the child want to enroll into a school, they'll also be the guardian. The guardian will have to consent to that. For leaving the country on a holiday, entering into various legal agreements or contracts, etc., purchasing homes. That's where the legal aspects comes in. It has nothing to do with physical communication with a minor child. To give an example, it's possible for someone to have no rights of custody, no rights of contact and care, but that person might have guardianship rights. So he might never see the minor child, or he may only see the minor child once a month, or she might only see the minor child once a month or once a year, whatever the case may be. But when it comes to the minor child applying for a passport, that specific parent's consent is required, and that parent can refuse, and if he refuses unreasonably, the court can get on board. So that's the difference between guardianship rights and custody. Guardianship applies to legal rights regarding a minor child. Question number 3 on child custody, before we're getting on to the divorce questions. Do mothers have more rights than fathers regarding minor children? The answer is no. I would say there is one point where a mother would have obviously more rights. It would be when a child is born. Because the child is born, the child needs to be more with the mother. If the mother is breastfeeding the child, etc. Maybe not more rights, but more responsibilities. Or it might be more the right of the child to have more contact with the mother, because the child is really young and tender, if it is in a minor child's best interest. But of course, if the mother, to give a bad example, is in substance abuse. She gave birth and she's totally incapable of looking after the minor child. And of course, the father would have to care for the minor child and make use of whatever resources available. But nonetheless, the general question would be no, mothers do not have more rights than fathers. Equal South African law looks at parents equally. The only issue that applies is who can better care for the minor child. If the father can better care for the minor child, of course, it makes more sense for the child to be cared for by the father primarily, and for the mother to have reasonable contact. First question regarding divorces. Question number 1. I got married in the USA. Can I get divorced in South Africa? Yes, you can get divorced in South Africa if you're living in South Africa. It would not work if you got married if you are a South African citizen, but you got married in the UK, lived in the UK, basically domiciled there because you consider the UK as being the USA, as being your home. And now you just come down to Cape Town for holiday, want to get divorced here. That won't work. We do not have jurisdiction. We can only divorce you if you are resident here or domiciled here, or you've been living in South Africa for quite some time. Therefore, you can get divorced here if you got married in the United States, but however, you need to be connected to the Pacific Court applicable. So therefore, even if you got married in Johannesburg and you're living in Cape Town for the last 10 years, you can't get divorced in Johannesburg. You need to get a divorce in Cape Town because Cape Town is the one where you were domiciled in. So yes, the answer, of course, is yes, you can get divorced in South Africa if the requirements are met. And regarding your matrimonial property regime, we might deal with it next week or the next time. Obviously, your matrimonial property regime would be the country or the city law that applied at the time of the marriage. Therefore, if you were married in South Africa and without an anti-nuptial contract, automatically you would have gotten married income into your property. That's how it works. Question number 2, how quick can a divorce be finalized? Yeah, I think with COVID-19, I would answer the question, how long is it string? Because it's very difficult to answer those questions in isolation. Nonetheless, a divorce can be finalized very quickly if the parties are in agreement regarding the divorce. That's very important. If you're in agreement, it can be finalized, let's say, in a month's time. If the parties are not in agreement, it can take very long. It can take months, sometimes years. COVID-19 and how difficult it is to finalize matters at court, it could take much, much longer. But nonetheless, if the parties can come to an agreement and it's sensible, because there should not be much to argue on. If they marry income into property, simple. If they marry other community property, even more simple. If they have minor children involved, getting expert to recommend something, and that should work. Question number 3. How does one enter into a parenting plan? Very interesting question. So when does a parenting plan apply? A parenting plan would obviously apply to a situation where parties are no longer living together, they're separated, but they have a minor child together, and now they would like to plan going forward. How do they work out? When does one parent have contact on a weekend? How does school holidays work? How does religious holidays work? How does Christmas work? Birthdays, Father's Day, Mother's Day, and so on, the child's birthday. So you should have a plan, so you should work it out. But if the family is different, one family, the father might be working normal, usual hours, 9 to 5, Monday to Friday. In a different family, the mother might be the one that works weekends at the waterfront, at that specific place. So she works weekends, the father does not work weekends. Or we might have a situation where one parent has to fly out of the country once a month or out of the province. So those are dynamics. And based upon those dynamics, you will create a unique parenting plan for your specific family and situation. And who would assist you with that? Usually an attorney could assist you, the office of the family advocate could assist you, a social worker, a psychologist, a reasonably qualified person, a mediator can assist you, and so on. So those are the people who would assist you, and they would assist you in drafting this agreement. And wonderful. Once an agreement is finalized, it can be registered at the office of the family advocate or be made in order of the court. So I hope that assisted everyone with today's webinar. Those are the questions. I see no live questions. It seems to me we have a better audience in the morning, but it's really difficult to say that because some mornings we're extremely busy with a lot of comments. Like yesterday morning, I was rushed with a lot of comments, which I'm very glad I had. Last evening, and I think we must just give it a proper time. But the reason why we are having these webinars at night, occasionally at night, is because many people, they complain we do not have an opportunity to pose questions live during the day because we're at work, and to see how it goes. But thank you very much for listening. Thank you very much for watching this video, and I hope to see you online again soon. Have a lovely day.